Hello and welcome to Barcast Audio Presents Evidence. This is our second module on character evidence. In this module, we'll discuss first, methods of proving character for truthfulness. Second, the distinction between how character evidence is treated in criminal and civil cases. Third, when evidence of a defendant's specific bad acts are admissible. And fourth and finally, we'll discuss character evidence in rape and sexual assault cases. Let's start with part 1, methods of proving character for truthfulness. Character evidence is evidence of a person's overall character or particular character trait. Statements like, Stringer is a liar, or Jesse is a peaceful person are examples of character evidence. Character evidence is generally proven in one of three ways. 1. Evidence of specific events or acts. 2. Opinion testimony. And 3. Reputation evidence. In committing these methods to memory, remember that discussing someone's character at trial can leave them sore. S-O-R. This will help you remember the three ways that character evidence may be proven. First, specific events or acts. An example of this kind of evidence is testimony at trial stating that I saw Walt cook meth. Opinion testimony. Contrast this with opinion testimony, such as, I personally believe Jesse is a reckless driver. And finally, reputation evidence. Reputation evidence must be put forth in relation to an individual's reputation within a particular community. Example, everyone in the community knows Gus to be a liar. Let's move on to the difference between character evidence in criminal and civil cases. First, civil cases. The central rule to keep in mind when thinking about character evidence in civil cases is as follows. Character evidence is not admissible to show a person's propensity to do something. This means that evidence of a person's character or particular character trait is not admissible as evidence that they acted in accordance with that trait. In civil cases, there are two primary exceptions to this rule. First, character at issue, and second, defendant's sexual misconduct. The first of these, the character at issue exception, provides as follows. Character evidence may be admitted to prove propensity where character is an essential element of a claim or defense. This primarily arises in defamation cases and cases of negligent management. If character is an essential element, then character may be proven by specific events, opinion testimony, or reputation evidence. Let's move on to criminal cases. In criminal cases, both the defense and prosecution are limited in their use of character evidence. First, in criminal cases, the prosecution cannot use evidence of a defendant's bad character to prove that a defendant had a propensity to commit the crime of which they are alleged. Defendants, however, may introduce evidence of their good character so long as it is 1. Pertinent to the crime alleged, and 2. Established through opinion or reputation testimony and not specific instances. Example, Tony is on trial for perjury. He seeks to introduce testimony from Trish, who will testify that she, quote, has personally seen him testify truthfully on 2 prior occasions. Is this evidence admissible character evidence? Answer, no. Here, Tony is trying to introduce evidence of his good character by evidence of specific acts. Thus, it would not be admissible. Example 2. What if Tony tried to introduce testimony from Spencer, who plans to testify that, in his opinion, Tony is a truthful person? Answer. In that case, Spencer's testimony would be admissible, as it is valid opinion testimony. If a defendant chooses to offer evidence of his positive character, he is deemed by the court to have, quote, opened the door to rebuttal on that character trait by the prosecution. This means that the prosecution is allowed to then introduce character evidence which negates defendant's evidence as to the character trait in question. The prosecution has 2 options in deciding how to rebut a defendant's character evidence. First, they may call their own character witness, or second, the prosecution can cross-examine the character witness put forth by the defendant. If the prosecution opts to call their own character witness, their witness is bound by the same testimonial limitations as the defendant's character witness. More succinctly put, any character witness put forth by the prosecution is limited only to opinion and reputation testimony. They may not testify as to specific acts by the defendant. This testimonial limitation does not apply when the prosecution opts to cross-examine a defendant's character witness. On cross-examination, the prosecution is free to introduce evidence of specific events or acts by the defendant, so long as they are pertinent to the character trait in question. Example: Mike is charged with forgery. Jay serves as a character witness for the defense, testifying that Mike had a reputation for truthfulness within their community. The prosecution seeks to ask Jay whether he was aware that Mike lied on his taxes last year. Will the court allow the prosecution to ask this question? Answer: yes. The prosecution may cross-examine the defendant's character witness as to specific instances. Let's move on to Part 3, specific instances of bad conduct. In both criminal and civil cases, evidence of a person's prior bad acts or criminal misconduct is generally inadmissible if offered for the sole purpose of establishing a defendant's bad character or propensity for criminality. However, specific instances of prior misconduct are admissible where independent relevance can be established. The sexual misconduct exception. In cases of sexual assault and molestation, evidence of defendant's prior acts of sexual assault or molestation are admissible. Let's briefly run through some examples to get a better understanding of this rule. Example: Hank is charged with the murder of Todd. The prosecution seeks to introduce evidence that Hank beats his wife for the purpose of establishing his propensity for violence. Is this evidence admissible? Answer: no. This evidence is being offered for the sole purpose of establishing Hank's bad character and does not fall within any of the so-called mimic non-character use carve-outs we'll discuss shortly. Therefore, it is inadmissible. Example 2. Hank is charged with sexually assaulting Marla. The prosecution seeks to introduce evidence that Hank had previously sexually assaulted 2 other women. Is that evidence likely to be deemed admissible? Answer: yes. This evidence is likely to be deemed admissible as an exception to the prior bad acts rule exists for evidence of a defendant's specific prior sexual misconduct. Let's talk about those mimic exceptions I mentioned before. While evidence of specific instances are generally inadmissible to show an individual's propensity to act a certain way, there are 5 non-character purposes for which specific instances are usually admissible. These 5 exceptions to the general rule are typically referred to as the mimic exceptions. That's M-I-M-I-C. Rule: evidence of specific instances are generally admissible to prove 1. Motive, 2. Intent, 3. Absence of mistake, 4. Identity, and 5. Common plan or scheme. There is a 2-step threshold requirement which must be satisfied in order for specific instances to be admissible for mimic purposes. This threshold requires that mimic evidence, 1. must be sufficient to support a jury finding that defendant actually committed the prior act, and 2. the probative value of the specific instances must not be substantially outweighed by the danger of unfair prejudice to the jury. This concludes our section on prior bad acts. Next up, we'll discuss Part 4, the rules invoked when character evidence is offered against victims. Part 4, victims. There are 2 important rules to keep in mind when a question asks about evidence offered against a victim, rather than a defendant. You'll primarily only see this in one of 2 circumstances. The first is where evidence is offered against a victim in a rape case, and the second is where evidence of a victim's character for nonviolence is offered in a homicide case. Let's talk about evidence in rape cases first. Look out for this rule where the facts indicate a defendant is on trial for rape and is attempting to introduce evidence of a victim's alleged promiscuity. In cases involving rape, evidence offered for the purpose of proving a victim's past sexual behavior or disposition is not admissible. There are 2 exceptions to keep in mind with this rule. First, in criminal cases, evidence of a victim's sexual misconduct may be admissible to prove that physical evidence of the rape, such as bodily fluids, came from someone other than the defendant. Second, in civil cases, evidence of a victim's sexual misconduct may be admissible if its probative value substantially outweighs the danger of harm to the victim and unfair prejudice to any party. Example: Stanley is charged with the rape of Stella. At trial, Stanley's attorney seeks to introduce evidence that he and Stella had previously had a consensual sexual relationship last year. Will this evidence be admissible? Answer: Evidence of a prior sexual relationship between the defendant and victim will generally be admissible. Next, let's talk about the second circumstance in which you're likely to see evidence being offered against a victim. That is, evidence of a victim's character trait for nonviolence in a homicide case. Generally, the prosecution may admit evidence of a victim's character for nonviolence if, and only if, the defendant claims the victim was the aggressor. Example: Tyrion is on trial for the murder of Jon. Tyrion says that Jon was the initial aggressor, chasing after him with a medieval sword after Tyrion told Jon he was short. In his defense, Tyrion claims that Jon was the initial aggressor. The prosecution seeks to rebut Tyrion's claim by offering evidence that Jon was known as a peaceful, non-violent person within his community. Is this evidence admissible? Answer: yes. This evidence would be admissible. The prosecution may admit evidence of a victim's character for nonviolence if a defendant alleges that the victim was the initial aggressor. This concludes the second module in our series on evidence. In our next module, we'll talk about impeachment and the introduction of physical evidence. Thank you for listening, and I'll talk to you soon.